All right, it's time for a little Q&A. Here's 10 questions that I get all the time, whether it's from a client in my legal practice, someone at church or at the hockey arena, a friend, and I'm going to give you some simple answers to these common questions. My name is Chad Graham. I'm an estate lawyer in Edmonton, Alberta. This video is intended for educational purposes only and does not constitute solicitor-client relationship and does not intend to give you legal advice. Question number 1. Do all wills need probate in Alberta? And the answer is no. It actually depends on what is in your estate and how it is meant to be handled. Here's just a few illustrations. If you have real property, land, apartment, housing in your name, then you must get probate in order to transfer it with the province and its registration system. If you have larger accounts with your financial institution or broker, each one has a little bit different internal standard. Generally, it's going to be something over $10,000. Then you will need probate. But if your estate is relatively small and you have no property in your name, or things are jointly held property or accounts, then you probably don't need probate. And your lawyer can help you to sort this out. How about a handwritten will? Are they valid in Alberta? Yes, they are. They're called a holographic will, and there's nothing invalid about them. They don't need a witness. They just need to be completely in the testator's hand and signed by them. Now, validity and advisability are two different things. While they may be valid, we don't advise them. Here's why. There can be a few challenges. I have actually taken some holographic wills through the court system and got them probated, and they worked fine. I've also had some that have been a disaster and required thousands of dollars in expenses to sort out. Especially a will written by an older person in a shaky hand or a messy handwriter like I am, there might be some confusion about what's in them. So if there's urgency, absolutely essential, do a handwritten will. It's better than having none, but treat it as temporary. Related to this, I got asked this the other day, could I write my will on the back of a napkin? And I guess the answer is yes. But that's kind of stupid. Have you ever seen stuff written on a napkin? The ink sort of blends in, it's hard to read. And I bet you if we brought this to a court, there's going to be a big question. Was this intended to be a will, or was this some kind of a joke done over coffee? If you're going to write a holographic will, do it right. Even better, the cost of a lawyer-drafted will is going to be peanuts compared to what you'll pay to sort out that napkin will. Here's some bigger stakes. Does marriage revoke a will in Alberta? This has become a bit of a point of confusion because in some provinces it does, and in some provinces it doesn't. Alberta is in the doesn't category. It's a common misconception. Marriage does nothing to change your existing will. So if you had a will before you were married, leaving everything to your parents or a sibling or a former partner you had that you weren't legally married to, well, that old will stand and your new spouse may get nothing, or actually more likely go through a court process costing tens of thousands of dollars. Takeaway: when you get married, update your will. Divorce is a little bit different. It's a mirror image of that. Divorce indeed does change the status of your will. However, not the way you might think that it does. It's incomplete. It revokes any gift given to your former spouse. It takes away any appointments, such as an executor. However, it does not deal with any gifts that are given through beneficiary designations, such as a TFSA or RRSP. Those need to be considered. Further, it only kicks in when the divorce is legally finalized. It does nothing while you're simply separated. Closely related to this, people want to know if they can disinherit their spouse. Sometimes there's good reasons for this, sometimes not so good reasons for this. Let me focus on the legal. You can try, but it's not that simple. In Alberta, the Wills and Succession Act gives spouses rights to support and maintenance. If you do not provide for them in your will, they can challenge and get support. There are all kinds of factors the court will consider: the size of the estate, the needs of the spouse, the length of the relationship, the applicant's contributions, the obligations of the deceased, and any other relevant circumstances. If the court determines the will has not adequately provided for them, it can order the estate to change its provisions. And that could have all kinds of downstream intentions that you didn't have. So it's best to figure this out on the front end. The Matrimonial Property Act also has some specific rules that can affect a spouse, and so you want to consider that as well. If you're thinking of leaving your spouse out for good reasons or not so good reasons, talk to your lawyer first. Related to that, can you disinherit adult children? Yes, and far easier than your spouse. Turns out, despite what you might think, your kids have nothing to hold over you. Under the Succession Act, Alberta Wills and Succession Act, adult children have no rights on their parents' estate. There are a few exceptions. If your adult children are unable to work or earn a livelihood because of mental or physical disability, you might have an obligation to support them. Minor children are an exception. You must support minor children. But if you plan to disinherit an adult child, go ahead. However, there is a wise provision to add a clause into your will explaining why. You know, my son told me a little joke the other day about the Canadian provinces and said the province of Manitoba is like the friend that you don't invite to your birthday party until the last day. Not because you don't like them, but because you forgot they exist. We don't want anyone to challenge a will saying, hey, the other kid's got it, because you forgot the youngest child existed. If you're a youngest child, you will appreciate this. How about an adult interdependent partner? I promised to come back to this earlier. Alberta does not use the term common law spouse anymore in its legislation. It uses the term adult interdependent partner. It's something similar to the old common law idea, but it's a little weird and it's governed by its own act. A lot of lawyers don't like it. A lot of people don't like it because they chose not to get married on purpose. Yet the government has said, you're not smart enough to make that kind of decision for yourself, so we're going to create a marriage-like entity and force it on you. Well, whether you like that politically or not, that's the reality. For estate planning purposes, this matters enormously. An AIP, an adult interdependent partner, has the same rights as a married spouse under the intestacy rules of the Wills and Succession Act. They also have the same rights to apply for maintenance and support. So if you're in a long-term relationship and you're not married, you may or may not be in an AIP relationship. Give your lawyer a call and decide whether this needs to be included in your plans. Okay, a little bit easier one. Where should I keep my will? There's a few options. Your executor needs to be able to find it. So you can leave it with your lawyer's office. That's fairly common. Your copy of your will that you will have and a letter will say that the original is with your lawyer. And the original is very important because in Alberta, you may only use your original to go for probate. It's like taking a photocopy of a $100 bill and taking it out and saying, hey, look at this bill. You can see the serial numbers. You can see that it's authentic. But no one will take that photocopy in payment. They want the real $100 bill. Same thing with your will. So your original can be with your lawyer. It can go in a safety deposit box. This can be a little bit of a catch-22 because most banks will say that your executor can't get access until they have a grant of probate. But to get the grant of probate, they need the will in the box. So you need to work out with your bank that they will give a limited opening in order to grab the will, and that can be done. At-home fireproof safes or even freezers are pretty common, and that can be okay as well. Just be very careful with it. Whatever you choose, tell your executor where that original is. Question 10, the final one for today. Do I need a lawyer to help me draft my will? Legally, the answer is no. There's absolutely no requirement that a lawyer help you in any way. You can write your own, holographic, or one of those templates you can buy at the store. If it's properly executed, it will be valid, and I've seen some that work. But practically, man, oh man, the cost of a lawyer-drafted will is almost always way less than fixing one that wasn't right in the first place. Here's what a lawyer brings to the table: precision. Legal documents say exactly what you mean in a way a court will understand and apply. Alberta-specific knowledge. A lot of these templates come from Ontario or somewhere else and do not properly comprehend Alberta law. Execution requirements. Formal wills require certain ways of signing, and your lawyer knows how to do that. Unless you've carefully studied it and done it right, it could mean your will is not valid. And then finally, coordination with your broader estate plan. All those things we talked about today or in the previous videos in this series will show you there's a lot to consider. And so you want someone who understands that and can think beyond the will to your big picture with you. So I'll put it this way. You can change your own oil in your car, and those who have studied it and do it well, go for it. But for the most of us, it's much more profitable to have a professional crack open that hood. Got a question I didn't cover? Drop it in the comments and I'll do a supplemental video. I'd love to answer your question. Are you ready to get your estate plan going and have a discussion? There's a link in the comments to contact me and start with a free consultation. Thank you.